Hello, everyone, and welcome to today's session. I am Angelica, head of the ALN Academy. The ALN Academy is an institute to promote the rule of law through education for the development of Africa. And today we are delighted to partner with Africa in the Moot in their collaborative training series with LCA, Young Arbitrators Network, YAN, and with Strathmore University Law School in preparation for the Willem C.Vis Moot with a particular focus on the skills needed to succeed in international commercial arbitration. We welcome our audience. We are live on Zoom and on YouTube. Please note that this session will be recorded in the ALN Academy's YouTube channel in case you wish to revisit it. We invite you to subscribe to our ALN Academy's YouTube channel in case you wish to access to more content related to rule of law. And also, please, if you have any question about this session, please do not hesitate to reach out to us at info@alnacademy.org. Now, please allow me to introduce today's speakers. We are delighted to host our guest speaker, Angeline Welsh, barrister from Essex Court of Chambers and board director of the ALN Academy. Angeline is a commercial litigator with over 15 years of experience and specific expertise in international arbitration. She has appeared and led before the English Commercial Court, the English Court of Appeal, and conducted substantial advocacy before both commercial and investment treaty arbitral tribunals. She has also appeared led before the Supreme Court and the Privy Council, as well as various courts in the Caribbean. In addition, Angeline has a substantial experience in handling
Hi, Angelica, you there? Okay, I think there's some issue with Angelica's network. So let me just continue. So thank you guys for joining. And I know that Angelica was midway introducing Angeline Welsh. And so we're so happy to have Angeline here. She's a barrister at Essex Court Chambers in London, UK. She has extensive international commercial arbitration experience, and so she'll be the one who will be taking us through this training. Myself, I am Tabitha Raore. I'm a senior associate at Angeline Kana Law Firm here in Nairobi, Kenya. And I am also a member of Africa in the Moot. Africa in the Moot, great, we have Angelica back. Hi, Angelica.
Yes, hi, I'm back. This is one of the issues of remote working. I'm so sorry, my apologies to all of our audience. So I think I was in Angeline's presentation. And if I'm not wrong, I was in the last part in which I was mentioning that Angeline is called to the bars of England and Wales, Belize, and the British Islands. Prior to becoming a barrister, she was counsel and solicitor advocate with a major international law firm. We are pleased to mention that Angeline was recognized as a global leader for arbitration by Who's Who Legal recently, and having been recommended for some time as both thought leader and leading junior at the English Bar of Arbitration. Angeline currently serves as co-chair of the ABI Arbitration Committee's ESG Subcommittee, on the ICC UK Selection Subcommittee, on the Arbitration Committee of the Lagos Court of Arbitration, and finally as board director for the ALN Academy. With no more introductions, Angeline, I try to be as brief as I can. I am now going to introduce to you our ALN moderator. So our ALN moderator today is Tabitha Joy Raure, Senior Associate at ALN Kenya and Jarwala Ankana, and Coach to Africa in the Moot programs. Tabitha is an advocate of the High Court of Kenya with 7 years post-qualification experience. She has an extensive commercial law background, having worked at ANK's commercial and corporate and projects and infrastructure departments. Tabitha advises on arbitration disputes and litigation matters, and represents parties before different courts and tribunals on commercial litigation, intellectual property, employment, probate, land, and human rights law matters. Tabitha was appointed as the International Chamber of Commerce, ICC, Young Arbitrators Forum representative for Africa in 2021 and 2023. She is also a beneficiary of the Association of Young Arbitrators, second mentorship program, and a dedicated member of the Africa Arbitration Academy, assisting it with various initiatives, including the Africa-wide litigation costs and disputes funding survey. She is a member also of the Youth Led in the Moot organization, and she's passionate about training in universities as Strathmore Law School and as Africa in the Moot. As a co-moderator, I'm pleased to introduce to you Christopher Awudimila. Christopher is a special assistant to the Honorable Attorney General of Delta State in Nigeria. And he's a member of countless international arbitration associations like the Young Arbitration International Group, the Young ICSID, the YSIAC, and the Association of Young Arbitrations. He has been also recently appointed as one of the 4 ambassadors of arbitrator intelligence from Nigeria. Christopher is a member of the Lagos Court of Arbitration. Today, then, I welcome you, and Tabitha, I give you the floor. Thank you.
Thank you so much, Angelica, for the kind introduction. So before we start, allow me to just mention a few words as to why we are having this training. As Angelica was pointing out, this is a part of a collaboration which exists between Africa in the Moot and the Young Arbitrators Network of the Lagos Court of Arbitration. We started this initiative because we noted that there is a gap in the training and coaching and overall support given to African students in the field of international commercial arbitration. In fact, we noted that in some universities, arbitration is not something that is widely taught as a module. And so we wanted to make sure that students on the continent who are signing up for some of these international mooting competitions have the necessary training to enable them to participate. Of course, as some of you will appreciate, a lot of training and support is provided to students who are participating from Europe, from America, on a global level. So we have a lot of catching up to do on this side of the world. And so we're really excited today to have you guys here with us. And we're excited to also have this introduction to commercial international arbitration provided by Angeline. So I would now like to hand over to Christopher to say a few words.
Thank you, Tabitha. Thank you for, and also thank you, Angelica, for the kind introduction. At first, I think I was also second guessing if it was me you were talking about. But thank you very much. And to our audience, we thank you for coming. Our speaker, Angeline, is well equipped and ready to, teach us today. And as much as possible, we want the section to be very interactive. So just to whet your appetite, the lecture for today will be in 5 parts. We'll talk about sources of law. We'll talk about arbitration agreements, and also give Angeline also, talk about the relevance of the seat and the place of arbitration. And fourthly, we'll also touch on applicable laws in arbitration. And lastly, interaction with national courts. So we also understand that just to promote interaction intermittently, we will try to, take questions from the audience. So just do well to, type in your questions or comments in the chat box. Would do well to stop at the end of the first and the second part of Angeline's presentation to take the questions. And also at the third and the fourth part, we also stop to take the questions. And at the end of the lecture, any question that you have, maybe at the end of the lecture, you have a new question you want to ask, just kindly type it in the comment section. We hope you have a nice time and that you learn. So at this point, I would like to yield the floor to our speaker for today, Angeline, to please comment the lecture for today. Thank you very much.
Well, thank you very much to Angelica, Tabitha, and Christopher. That was a tremendous introduction, and I'm impressed by Angelica's negotiation of technological problems, and I hope she's going to help me a bit more by putting up the slides for my talk today. So Angelica, if you could share the screen with my slides, I appreciate it. While Angelica is doing that, I should say, there we go, brilliant. Thank you very much. Christopher has already outlined what I'm going to... Sorry,
Angeline, can you see the screen? Is it okay?
I can, thank you very much, Angelica.
Okay,
that's
lovely.
Perfect.
Thank you.
So Christopher has already outlined what I'm going to talk about today. My aim today is to give you arbitration law, the basics. So what I'm not going to spend much time talking about is the procedure in international arbitration proceedings. I'm going to talk about the legal structure which surrounds arbitration and what makes it effective. You've already been encouraged to ask questions. Please, may I strongly encourage you to ask questions through the chat box, and then we will be able to answer them as you go along. So Angelica, if you could move forward to the next slide, and then the slide after that, and we'll start at the beginning of my talk because the audience already had the outline. Excellent, thank you. Sorry, if you go back a slide. To sources of law, number 1. That's it, perfect, thank you. So the first thing I'm going to talk about today is the different sources of law. And what I really mean by this is the legal framework for the law of arbitration. And I wanted to start, before I get into the various different layers of law which potentially apply to an arbitration process, I wanted to emphasize that the starting point for arbitration is that it is a consensual process, and that's really important because it informs a lot of the issues which surround the enforcement of an arbitration agreement and, of course, the resulting arbitral award which you get at the end of the process. And what I mean by that is the only reason that arbitration exists is because the parties have agreed to it. And so I'm not going to spend a lot of time talking about the pros and cons of that decision, though I'm happy to answer any questions anyone has on it. But the fact that there is a contractual agreement to arbitrate, I do want to emphasize, is central to understanding arbitration law. And what the legal framework essentially does is upholds this and enforces this core agreement. And I also want to say that arbitration can be used in different contexts. So you can have a domestic arbitration, you can have an international arbitration, you can have commercial arbitration or investment treaty arbitration. What I'm really going to focus on here is international commercial arbitration, although I will refer to the International Treaty for Investment Treaty Arbitration. And what I really mean by international arbitration is frequently those types of disputes which are cross-border, where you have perhaps parties in different jurisdictions. And what part of the reason why arbitration has been successful, or at least one of the reasons why, is that parties from different jurisdictions, rather than have their disputes resolved in the national courts, will choose to have them resolved in arbitration, which they would regard as a neutral forum. And so the legal framework really needs to operate in more than one jurisdiction. And what I want to really look at now is how has that been achieved. So Angelica, if we could go to the next slide. Okay, sources of law, number 1. This is the first item in my talk on sources of law, and what I'm starting with is the international frameworks, the international law which applies to support arbitration proceedings. The backbone of international arbitration, and particularly international commercial arbitration, is without question the New York Convention. It now has 168 contracting states. And given that there are 193 member states of the United Nations with only 2 with observing status, that's pretty close to universal global coverage. Why is the New York Convention the backbone? Well, because it includes in particular two key provisions which enforce the agreement to arbitrate. First of all, it requires contracting states to recognise an arbitration agreement and refer parties to arbitration unless that agreement is null and void, inoperative or incapable of being performed. And that's something we're going to come back to later in this talk. And secondly, it requires contracting states to enforce an arbitral award, save for in very limited circumstances, which again, we'll come back to. As a result, this widely adopted international treaty has been pivotal to ensuring that national courts enforce arbitration agreements and awards on a uniform basis. The second international treaty, which is of particular note, I've added to the slide, is the ICSID Convention, which has also been broadly adopted, although not quite as broadly as the New York Convention, but pretty close to it. 155 parties have ratified it as at October 2021. So ICSID is a World Bank Group organisation that administers arbitrations. And what the convention does is it establishes a legal framework for investment treaty disputes, which are arbitrations between a company or individual investor against a state for breach of the state's obligation under international law to protect the investor's investment. It's very similar to the New York Convention in some ways, save that it is more robust in some circumstances, for example, on the obligation to enforce ICSID awards. And it does other things besides, because it establishes ICSID and the constitutional framework for that organisation. Okay, so then if we can go to the next slide, please, Angelica. Okay, so now we're on to the national law on sources of law. So that's the next tier down, if you will. So what about the national sources of law? Well, it's frequently the case that a state will have a national arbitration law, and it may be that many of you are pretty familiar with what your own national arbitration law looks like. And that's not least usually because if you are dealing with a dualist jurisdiction, as many common law jurisdictions are, it will be necessary to give effect to the state's international obligation under the New York Convention by enacting domestic legislation to ensure that the state's obligations under that treaty are also reflected in national law. So it's very often the case that there is a national law. It's also often the case that that national law is based on the UNCITRAL model law. That is effectively a standard form off-the-shelf arbitration law, which and so frequently what it does is it translates into national the provisions of the New York Convention. It gives some additional provisions as well, some of which we will look at, to allow courts to support arbitration proceedings. Such as, for example, the obligation to stay court proceedings in favour of arbitration and the obligation to enforce arbitral awards. And the Kenyan Arbitration Act, which I put on the slide, is an example of where the UNCITRAL model law is relatively closely followed. The British Virgin Islands is another example of that, although they have additional tweaks to their law, if you like, particularly on the issue of confidentiality. The English Arbitration Act 1996 is quite different in some ways to the UNCITRAL model law. A lot of the core principles are there, but the English have decided that they're different, and they've added various bits to their pieces of legislation. So that's something to bear in mind, because quite often one looks to English case law, particularly in Commonwealth jurisdictions. And in fact, the English law sometimes looks to Singapore law. So there's a significant amount of cross-fertilization, I think, in terms of common law jurisdictions. But you have to be a bit careful, because obviously if the legislation is doing something different, it may not be applicable to your national arbitration law. So that's what I wanted to say, particularly relevant to case law, because there will be, for common law jurisdictions, a huge amount of case law which exists, which interprets provisions of national arbitration law and recognises key concepts of arbitration law in common law. But one has to be a little bit careful to check that the legislation is the same. If we can go to the next slide, please, Angelica. We're on to sources of law, slide 3, institutional rules. So we just need to go forward.
Is it this one, or should I go to the next one? I'm sorry.
Next one.
This one?
Yeah, that's the one. Brilliant.
Okay.
Thank you.
Okay.
So sources of law, institutional rules. So if we think we've looked at the international, we've looked at the national, drilling down a bit further, there's also institutional arbitration rules, and these are adopted by party agreement. So it's quite often the case that the arbitration clause that you're dealing with will stipulate in there that the arbitration will be conducted under certain arbitration rules. And those rules oftentimes, most often, are attached to a particular arbitral institution. And oftentimes in that case, the arbitral institution will also administer the arbitration. And what I mean by that is they will probably hold funds for the tribunal, they will become involved in the appointment of the tribunal, and they will perform some lesser or greater extent in scrutinising the award and so forth. And that's what we know as institutional arbitration. And I've listed some major arbitral institutions on the slide, some of which you will know: London Court of International Arbitration, the International Chamber of Commerce, the Nairobi Centre for International Arbitration, Lagos Court of Arbitration, and the ICSID arbitration rules, which apply for investment treaty arbitration. So those are institutional arbitration rules. We can also have ad hoc arbitration. And what we mean by ad hoc arbitration is that there is no arbitral institution which is administering the arbitration. But that's not to say that you don't necessarily have arbitration rules. If parties have agreed that certain rules might apply, then they would apply regardless of whether the arbitral institution is administering the arbitration. Most of the time, if you agreed an institutional rule, as I said before, the institution's administration will come with the rules. But the Untitled arbitration rules, 2010 is the latest version, but there's also with transparency provisions which were added in 2013, are arbitration rules which do not come with an institution, and they are known as ad hoc arbitration, no administration, but you still conduct the arbitration in accordance with the Untitled arbitration rules. Now, what do the arbitration rules do? Why are they relevant? Well, they're quite often selected because they will import certain rules into the conduct of the arbitration itself. So, for example, they may set out the default procedure for exchange of pleadings, or they may include certain provisions which deal with challenge to arbitrators. Some may be quite prescriptive and effectively require delivery of awards on a certain time. They may, it's becoming increasingly common for some arbitration rules to provide for emergency arbitrators and so forth. But they are the guide, if you like, by which the arbitration will be conducted, although they're still very light touch compared to court procedural rules. But that is why they're selected, and they've quite often thought through some of the tricky procedural issues which could crop up in arbitration. So the recommendation is always, if you're going to have an arbitration clause, then you should select institutional arbitration rules, because it will make the whole running of the arbitration process much smoother. There's obviously pros and cons between various different institutional rules, and I'm not going to go into those now. The next slide, please, Angelica, which is my final slide on sources of law, soft law. Thank you. So I've added this because there are some rules and guidelines, and there's a huge amount in arbitration because the arbitration community like to contribute to the development and learning in their area. So I've listed two very prominent guidelines on the slide, but there are countless guidelines. There's guidelines which exist, or protocol which exist for virtual hearings and so forth in light of the pandemic. So it's oftentimes, if you're looking for some guidance as to how to conduct arbitration proceedings, it's worth seeing what is out there in terms of guidelines. The guidelines are soft law because unless the parties have agreed to adopt them, there is no obligation on the tribunal or the parties to use them, but they're quite often referred to for particular issues. And the two on the slide are ones that are most often used. here I have the IBA rules on the taking of evidence in international arbitration. And that, for example, will set out, well, if you're making a request of documents in your arbitration, what is the form in which that request should be made, and what is the guidance on what the tribunal should take into account when determining whether to order production of documents, for example. So that's that's typically included in the first procedural order of the tribunal, and it's very widely adopted. And it may even be you'll see it in your arbitration clause. The second on the slide, which is also very often adopted, is the IBA guidelines and conflicts of interest in international arbitration. And they identify through a traffic light system the types of situation in which an arbitrator may have conflicts, and so therefore needs to disclose certain circumstances to the parties so they can decide whether they have an objection to that arbitrator continuing or not. And equally, it lists in the green section those circumstances which don't require disclosure. So in the red section, it has a list of certain circumstances which would prohibit the arbitrator from sitting, and it also has a set of circumstances which, unless the parties expressly waive it, would prohibit the arbitrator from sitting. Orange is something which should be disclosed to the parties but doesn't necessarily stop the arbitrator from sitting, and green is circumstances which do not need to be disclosed. And that's very often looked to by arbitrators when considering whether to accept appointments, but also if you're thinking about challenging an arbitrator. But you have to be careful with soft law because they're not always foolproof in a sense. So just taking the conflicts of interest in international arbitration, for example, later in my talk, I'm going to look at when a court may remove an arbitrator, and the test under English law, which is quite broadly adopted elsewhere in other Commonwealth countries, is not the same test that one would necessarily apply in the IBA guidelines. So in theory, an arbitrator could comply with the IBA guidelines, but still fall foul of the English law on whether there's apparent bias or not, and therefore justify his or her removal. So these are helpful guidelines, but they're not necessary to follow unless they're incorporated into the party agreement. Now I'm going to move on to the second part of my talk, which is the all-important arbitration agreement. And I've already said something about the importance of the parties' agreement to arbitrate. If we can move on to the next slide, please, Angelica. Now, this is the agreement which requires disputes to be referred to arbitration, and also the obligation to comply with the resulting award. Typically, an arbitration agreement would set out what is being referred to arbitration, so the scope of the dispute which may be referred, the seat or legal place of the arbitration, which I'm going to come back on to later, any applicable arbitration rules, which we've just looked at. It can be included as a clause in a contract. So when parties are putting their contract together, but they don't know what their dispute is, at that stage, they may say, well, look, if a dispute arises, we're going to arbitration. Or it can be a freestanding agreement. And that is probably more likely in circumstances where dispute has arisen, parties don't want to go to court, but they prefer arbitration. They can agree at that point to go to arbitration. It is similar to or akin to an exclusive jurisdiction clause, which means that by agreeing to arbitration, you're effectively excluding other dispute resolution mechanisms like a national court most often. The doctrine of separability applies to the arbitration agreement. So what is the doctrine of separability? Because this is something which, at least as a matter of English law, also applies to a jurisdiction agreement. And what it means is that it's a legal theory that the arbitration agreement, which even if it forms part of an overarching contractual agreement, say you had a consultancy agreement, and within that consultancy agreement, you have an arbitration clause, the arbitration clause or the validity of the arbitration clause is considered separately to that overall consultancy agreement. So let's say, for example, that there is an allegation that under the consultancy agreement, the purpose of the consultancy agreement was that the consultant would bribe ministers to procure a particular contract or something like that. That allegation may impugn the consultancy agreement for being unlawful, but it doesn't necessarily impugn the arbitration agreement. In order to say that the arbitration agreement itself is voidable, you have to say that there was something unlawful which goes directly to that arbitration agreement. And the reason why the doctrine of separability is so important is that if a party wanted to avoid the arbitration of that consultancy agreement and whether or not it's lawful, all they would need to do is just seek to impugn that consultancy agreement full stop. And then you would, if the arbitration agreement wasn't separable or dealt with separately, then you would just automatically go to the English court or whatever court it was, which is potentially relevant to the resolution of that dispute. Whereas because of the doctrine of separability, the arbitration agreement may still be valid, even if the consultancy agreement is not, and therefore the tribunal can continue to determine that particular dispute. So that's why the doctrine of separability is of particular importance. And as we'll go through, you'll see that I'll talk about the potential impact that has on applicable law, but that is quite an important basic theory of arbitration law, if you like. So if we can move on to the next slide, please, Angelica. So we're on to arbitration agreement form. What are the core requirements? So a moment ago, I talked about what you would typically see in an arbitration agreement. And there's a shopping list of things that you would typically see in it, really to make it an effective agreement. And they're all really important. But in order to have a valid arbitration agreement, you actually don't really need very much at all. So the core requirements are pretty minimal, and they're set out both in the New York Convention and then are reflected in the model law. It tends to be that the model law actually in national arbitration laws as a result are a bit broader than the New York Convention, which is a convention from 1958. And so the New York Convention requires that the agreement is in writing. It says it can be a clause in a contract or a separate agreement, but it must be signed or contained in an exchange of letters or telegrams. And as we all know, exchange of letters or telegrams is a pretty archaic language these days, it turns out. So under the model law, it can be concluded orally. So it's really important to, if you're thinking about, well, what is going to be a legally effective arbitration agreement, you look to the law, probably at the seat of the arbitration where the agreement is likely to be, the validity of it will likely be upheld, and check that it meets their core requirements. And as we'll look at also, it's also important to check that the applicable law of the arbitration agreement, the core requirements of that applicable law are also met. And working out the applicable law of the arbitration agreement can sometimes be a bit tricky. I'm going to cover that. The final point in this slide is incorporation by reference. So as I said, an arbitration agreement can be in a separate agreement. The example I gave earlier was an example of where the dispute has arisen and then you agree a separate agreement for arbitration. But it is also possible that you agree a contractual agreement, but your arbitration agreement is in a separate agreement at that particular time, but it may still be incorporated into your main agreement. And that's why I've put on the slide incorporation by reference. And that's really a question of whether or not arbitration agreements in a separate agreement have been incorporated as a contractual construction question. The classic example is where you are contracting with another party and you're contracting on their standard terms, and their standard terms include an arbitration agreement. And in those circumstances, the whole of the standard terms are incorporated into your agreement, including the arbitration agreement. The position is a bit more complicated where there's a reference to non-standard terms, but that's something perhaps we can explore if anyone's got any particular questions about it. Okay, so if we move to the next slide, please, Angelica, on scope. Thank you. So it used to be the case that there was a lot of debate about what is the scope of disputes which are being referred to the arbitration agreement, to the arbitration. And the approach to determining what the parties have agreed to refer to arbitration is to look at the language of the arbitration agreement itself. And you will typically find language which says disputes arising out of, arising under, arising in connection with the main contract, the matrix or underlying contract, if you like. In 2007, the English House of Lords, in the case of Vienna Trust or Premium NAFTA, it's sometimes referred to, said that when considering the language on scope, there is a presumption of a broad construction of the language that individuals have used. And that's because the parties have presumed to have favoured a one-stop adjudication. So commercial individuals agreeing or entities agreeing a contract are assumed that what they want to do is refer as much of their disputes arising out of their relationship to one forum, and if they've agreed arbitration, it's arbitration, rather than splitting up between various forums, like some disputes going to the court, some disputes going to arbitration, which can get really messy. So now, at least in many common law jurisdictions, we favour a very broad interpretation of the language, regardless of what language is being used. The next question arises, well, what disputes are arbitrable? Are there any disputes which can't be, even if you agreed to refer them to arbitration? Is it, as a matter of public policy, not possible for them to be determined by an arbitral tribunal? And it's interesting that the arbitrability objection, i.e. not suitable for determination by a tribunal, is something which features as a ground for refusing to enforce an award. We'll come back to that, but so it's in the New York Convention, also in the Untitled model law. But the sort of trajectory, if you like, of challenges and arbitrability are that it's becoming a narrower and narrower cause for an objection. So they're becoming almost very limited circumstances in which matters will be found not to be arbitrable. Certainly criminal proceedings which lead to a conviction and criminal penal sanction is not arbitrable, and one can see good public policy reasons why you can't have a private tribunal determining that sort of allegation. But fraud, as a civil claim, is. And there is, and it used to be, but things have moved slightly. So it used to be that it's thought that insolvency claims, for example, are not arbitrable. But in a recent English case, Riverrock Securities Limited, claims characterized as insolvency claims as a matter of English and Russian law were found to be arbitrable because they didn't affect the rights of third parties. So one of the issues which the court is concerned about is in the private arbitration between two parties, is the dispute going to affect third parties? And if it won't, then arguable it's arbitrable. So we've gone from insolvency claims not being arbitrable at all to potentially there being arbitrable depending on the circumstances. Finally, scope. I just wanted to say that I think it's wrong to think that only contractual claims can be brought in arbitration proceedings. Really the question is, are the disputes arising out of the contractual relationship? And so some disputes which are not brought under contract, but in, for example, tort or restitutionary claims, may still fall within the scope of the arbitration. It's not just contractual disputes. I'm going to stop there and see if I can tempt anyone to ask me some questions before I move on to the next phase of my talk.
Hi, Angelica, we do have some questions on the chat. So allow me to read out one of them. So someone has asked, why does the Untitled model law fall under national law and not international law?
Yeah,
I think this is with respect to slide 2, I believe, of your presentation.
yes, thank you, Tabitha. So the reason why I put international law is the Untitled model law is, it's like a pro forma. It's developed by Untitled as a suggested law which can be adopted by nations who want to implement the New York Convention obligations into domestic law. So it doesn't by itself, the Untitled Model Law is a suggested piece of legislation. It doesn't have any effect. It's not legislation in itself, but national legislatures will then bring in their own national legislation, and typically what they will do is adopt either the text of the text of the Untitled Model Law as their national legislation. So the Kenyan Act is the Kenyan Arbitration Act, but it broadly follows the Untitled Model Law, if that makes sense. So that, I think, is the answer to that. There's another question. Do you want me to just take them, Tabitha? I don't want to take you out of...
Yeah, that's okay.
Okay. Is case law regarded as soft law in arbitration since it acts as more persuasive authority rather than as binding authority on arbitral tribunals? So it may be best that I come back to this in the context of applicable law, but there are different applicable laws. If you're looking at, say, a contract which is governed by English law, if I can use the English law example, then the tribunal has to decide disputes arising out of that contract as a matter of English law. And so English case law is it's not binding authority in the sense that they're part of the court, but it is binding authority because that's English law and they're bound to apply English law, if that makes sense. So I wouldn't describe English law as soft law because the tribunal is bound to apply the governing law which applies to the substantive dispute, including relevant case law. Right, so then I've got, will the separation doctrine interfere the legality of the whole arbitration process, especially in light of an illegal contract? So the separation doctrine, the best way of thinking about it is to say that it puts a protective ring around the arbitration agreement. So if someone were to say that loan that was entered into, it was procured by bribery and therefore it was an unlawful loan, but it contained an arbitration agreement. The procuring of the loan itself by bribery may make the loan completely lawful, but doesn't necessarily mean that the arbitration clause is unlawful. The question is, more in order to set aside the arbitration agreement itself, you have to impugn directly the arbitration agreement. So did someone choose to agree to arbitrate rather than go to the national courts because they received a bribe to do that? Has to be directly impugning that agreement, and that comes out of the Fiona Trust Premium NAFTA case law. So in fact, the separation doctrine allows the tribunal to decide allegations of illegality in relation to the main contract. The Lagos Court arbitration rules, is it a national or international arbitration law? It is neither. It is essentially the best way to think about arbitration rules. It is to think about them as part of the parties' agreement, arbitration agreement. It's like an extension of the arbitration agreement. So if I were to say, in my arbitration agreement, I agree with you to conduct arbitration under particular institutional rules, I'm effectively importing into our agreement that the arbitration will be run in accordance with those rules, and we've signed up to those rules. Now, there's lots of discretion in those rules for the tribunal to do something different. The parties can always agree to take certain parts of the rules out and not follow them. That's completely within their discretion, but it's there by virtue of party agreement rather than a national law or international law. Now, I think I've answered, the Untitled Model Law points as to why it falls under national law. But if anyone's still confused about that, perhaps you can raise it still in the chat. Tabitha, is there anything more you want to talk about before I get on to the next part of the seminar?
Yeah, actually, it's just something that I've been thinking about based on the most recent question with respect to the rules as to whether that's national law or not. And I was thinking whether you can clarify that, in the event that you have your rules conflicting with the national law, for example, an Arbitration Act or something like that, what happens in that type of situation? Because that might help to explain why you can't then see the rules as a national law.
Oh, I see. Well, can we come back to that question as part of the different applicable laws? Because I think what we need to do is break down the various different laws which apply to arbitration proceedings. And perhaps I just give a short answer to that question, if I can, before we go to that, which is what the national law does is it provides basically the rules by which the court will support the arbitration process. The institutional rules are effectively the procedure for the arbitration, and normally a national law is pretty silent on the procedure of the arbitration. There's a bit of overlap, but quite often the national law will allow the parties to depart from some of the procedural aspects agreed in the national law by party agreement, subject to certain mandatory requirements which are there as a matter of sort of public policy. So, you know, the fair conduct of fair and efficient conduct of an arbitration proceedings and so forth. So they're really driven at or targeted at different things in the arbitration process. And it is possible that you could have a mandatory provision of your national arbitration law, which an institutional rule conflicts with, and the national law would take precedence. But that actually very rarely happens in practice, because the institutional rules are often drafted with the core principles of arbitration reflected in national laws in mind. And so actually, I'm not aware of a circumstance where the institutional rules have said to conflict with the national law, such as to have the effect of setting aside the arbitration agreement or the award or so forth. But they're really targeted at different things. Anything else from anyone? Christopher, I don't know if you want to ask any questions, or should I move on?
Okay, if at all, I mean, I also have the question Tabitha asked, but then two questions. Firstly, there are instances, I know that you talked about soft laws. So I'm sure you might also want to defer this question to when you talk about applicable laws. I'm almost very sure. That's why I'm reluctant to ask, but regardless. So there are instances where there's a question as to the applicability of soft laws, situations where the parties have not expressly, agreed to adopt those soft laws. I also know that for the Lagos Court of Arbitration in Nigeria, a decision by parties to submit their dispute to the LCA is also a tacit, acquiescence to the usage of those two IBA, the guideline and also the rules that you highlighted. But it's not, there are situations where it's not expressly stated. So in those where is there a balance between the applicability most times, even if we know that at the beginning of a tribunal would always ask parties for, the applicable procedural laws that they want to adopt, or if they want to use those soft laws. Then secondly, if you can comment on the advent of, the way parties draft arbitration agreements with so much, less details, that it leaves a lot to be desired. So, on those comments, instances where you don't have sufficient details, where you don't have the seat of arbitration stated, and a lot of omissions by parties, you can just, make a comment on that too.
Okay. So I think the first question goes to the circumstances in which tribunals will impose some of the soft law guidelines. So, for example, the taking of evidence and so forth. Now, on that, it's quite, the parties, I think, and what sort of law the tribunal will look to fill in gaps. Then we'll come back and talk about drafting of arbitration clauses. We'll come on, I think, on applicable law to sort of bottom out the different potential laws. It really depends on what the detail is in your arbitration agreement. But generally speaking, if you've adopted institutional rules, then that will provide a very good framework for the way in which the arbitration should be conducted. But ultimately, the reason why parties choose arbitration is that they want to get away from the rules and regulations of court proceedings. So you select your arbitrators, or you hope that your arbitral institution will select your arbitrators to impose a procedure which is most suitable and efficient for your case. So there may be some cases which are really, there is revolve around the clause in one particular contract and what it means. In those circumstances, evidence may be of very limited value, and what you want is a tribunal to put in place a very short timetable for pleadings, no evidence, no documents of disclosure, and you want them to focus just on the interpretation of that clause, in which case some of the institutional rules may not be that relevant. Sometimes parties may agree to bring in soft law provisions like the taking of evidence and so forth. Sometimes the tribunals will make it part of the procedure by putting it in their first procedural order and say the parties will follow these rules. More often what they do is they say parties will be guided by the taking of evidence. So you make it clear that that's the inspiration, but nobody's going to be ticked off if you don't follow it to the letter. That's normally the way in which it's approached. But in terms of taking inspiration for what the procedural rules should be, tribunals quite often look to the seat of the arbitration. I'm going to come on and talk a little bit about what the seat of the arbitration is. Very quickly on drafting. Arbitration clauses can be very simple, but they can be incredibly complex, and it really depends on the nature of the contract. I think I set out earlier what I think should be included in an arbitration clause. So you should have broad language which describes the types of dispute arising out of or in connection with, arising under. That's the sort of scope. You should include institutional rules. You should definitely include what the seat of the arbitration will be, and we'll come and talk about seat in a moment. I think it's becoming increasingly important to stipulate what the law is which applies to the arbitration agreement, because that can be different to the law of the main contract if you want it to be. And the law of the arbitration agreement is very important because that will determine what law applies to the validity of the arbitration agreement and therefore the tribunal's jurisdiction. You can have multi-tier clauses, so it's very common for an agreement to provide that the parties will negotiate beforehand and then go to arbitration. And there's particularly drafting rules which arise around that, because you don't want to put such stringent drafting in place which requires you to negotiate without a deadline, for example, by which if no one's reached an agreement, you can go to arbitration. Because if you're not able to comply with the first aspect, if say it just says the parties shall negotiate, and if they're unable to reach an agreement, you can go to arbitration, then all one party has to do to frustrate the arbitration process is just not agree. So there's quite a lot of different drafting points around arbitration clauses, and also if you've got arbitration clauses and related agreements, whether you can join disputes arising under those different agreements. So I don't have time to go into all of them now, but it is really quite a broad topic in itself, and in the drafting of arbitration clauses does require careful consideration. Should I move on in that case?
Yes, please. Let's just move on.
Okay, fine. I can see that applicable law is going to get quite a lot of attention, so I'll hopefully spend some time talking about that. Angelica, if we can move on to the next slide, please. So seat or legal place of the arbitration. And if you move on to the next slide, this is a really important key concept of arbitration. what you will normally see in an arbitration clause is that arbitration shall be held in, I've just put Nairobi, but it could be any sort of, normally it's a city, it's a major city. And what that does is it gives the arbitration a juridical home. So it's either, you either normally see it referred to as the seat or the legal place of the arbitration. Venue typically means where the hearings will be held, and it's not the same as a seat, although it could be depending on how the clause is construed. So you have to be really careful, and it's best practice to say seat or legal place, and then you're not in any doubt as to what this means. So what is a seat? It's a bit of a weird but core arbitration concept. It's essentially the juridical home of the arbitration proceedings. So if I have an arbitration which is seated in Nairobi, that would mean that the legal infrastructure which attaches to that arbitration proceedings is to be found in the national law of Nairobi. And if, for example, you wanted to remove an arbitrator or you wanted to challenge the award when it comes out at the beginning, then you would go to the jurisdiction at the seat of the arbitration in order to do that. So it's a very important choice because you want to make sure that it is seated in a jurisdiction which is very familiar with arbitration proceedings and will do the right thing in terms of upholding your arbitration agreement and your arbitration award eventually. The reason why it's also important is, as I said earlier, it will often fill the procedural gap. So arbitration is a very international process now. If, for example, you had an arbitration seated in London, the fact that it's seated in London does not mean that as a default you look to the English civil procedure rules and you decide, okay, what do I do on disclosure? I will impose the civil procedure rules. That's not really how it works anymore, because the whole point of arbitration, as I was saying earlier, is to get flexibility to move away from the court rules. But nevertheless, if there are any procedural law issue, the tribunal will probably look to, if it's seated in London, English law or Nairobi, Kenyan law. So you want to be very careful about the selection of your seat. There's also a presumption that that's probably where the hearings will take place, but it's not necessary. And sometimes you might see arbitration clauses which you could say seated in London, but the venue of the hearings will be Nairobi. And so that is a presumption that all the hearings will take place in Nairobi. And also, I think, increasingly we're in the post-pandemic world, we're in a situation where it could be seated in London, but all of your hearings are taking place on a virtual platform like Zoom, and the participants are in several different jurisdictions all over the world. So it is, you mustn't confuse seat or legal place with actually physically where the hearings are held, because it can be a very different thing. Now, moving on to applicable law, if you can move to the next slide, Angelica. And then move forward to the slide. That's it, perfect. Just stay on that. We've talked already a bit about applicable law. So it's worth, I think, breaking down what are the potential applicable laws to arbitration proceedings. What I'm going to really focus on is substantive law, the law applicable to the arbitration agreement, and then the law applicable to procedure. On substantive law, that is the law which determines the law applicable to the substance of the dispute. So you have a dispute arising under a contract. What is the law which governs the contractual relations? Normally, this is really easy to determine because the types of contracts that you'll be dealing with will have a governing law clause, and that will deal with the substance of the dispute. If not, then the tribunal may have to apply a conflict of law rules to determine the substantive law. It's not set in stone which conflict of law rules will apply. It's the ones oftentimes the tribunal thinks is appropriate, but quite often you look to the law of the seat and the conflict rules there to determine the substantive law. But as I said, it's not set in stone. The second applicable law is the arbitration agreement. And there has been quite a lot written about this recently. So I'll try to sort of take it as quickly as I can. This is potentially very important because it governs whether or not the arbitration agreement is valid, how effective it is, and how it is to be construed. So, you know, when you're looking at what is the scope of the disputes which the parties have agreed to refer to arbitration, that's really a question of contractual construction of the arbitration agreement. And as I said earlier, it's not common for arbitration agreements to specify what law governs it. Although you can do that, you can certainly include in your arbitration agreement what law governs it. The reason why this has received quite a lot of judicial attention recently goes back to the issue of the doctrine of separability, which we were discussing a moment ago. So this idea that you have an arbitration clause which is cocooned, if you like, by the doctrine of separability from the main agreement. If there is no law specified in the arbitration agreement, assuming that it's likely that basically the tribunal will have to determine what law applies, and they will look to the choice of law rules governing the arbitration agreement. And the debate that we had under English law, and there are also Singapore cases on this, was whether or not you should follow the seat approach, which is that the law applicable to the arbitration agreement is taken from the seat. So say that you had a contract which was governed, the main substantive contract was governed by English law, but the seat was Paris, then the law of the seat would be French law. And because of the doctrine of separability, the argument was made, well, the law which applies to the seat, it would in that case be French law. And that was the way in which, broadly speaking, the courts approached it in the English courts in South America, which is a Court of Appeal case from 2012. In Singapore, there were cases going both ways. First Link Investments Corporation, it was held that the law of the seat should generally apply to the arbitration agreement. But in the subsequent case of BCY and BCZ, the presumption was that the express choice of New York law governing the main contract governed the arbitration agreement, and that wasn't displaced by the choice of Singapore law. So the main contract theory is to say, well, the parties have put in their contract what law governs the contract, and that governs the entire contract, which includes the arbitration clause. So if there's a governing law in the entire contract, then it should govern the arbitration clause. Now, the English Supreme Court in 2020 looked at this in the case of Enker and Chubb, and they essentially endorsed the main contract theory, having reviewed extensively the key authorities in the area. And in doing so, they overturned the Court of Appeal case in Enker, the previous Court of Appeal case. So the way in which the applicable law to the arbitration agreement is determined is through essentially a two-stage analysis. The first stage is to ascertain the intention of the parties, whether it be on an expressed or an implied basis. And this is because under English common law rules of conflict rules, the starting point is to ascertain whether there's been a choice of law. So that choice can either be expressed or it can be implied. And in Enker, the Supreme Court recognised that many of the cases applying the common law rules made a distinction between express and implied choice, but they noted that the distinction was not a sharp one, and that interpreting whether the parties have agreed on a choice of law to govern their contract in every case, it's a question of interpretation. So they then said, well, if you're doing essentially an exercise in contractual interpretation, this endorses the main contract approach, because if the parties have decided to put in a choice of law governing the main contract, that should be construed as applying to the arbitration agreement itself. So that is the way in which the English law would now approach this question. So starting with, is there an express or implied choice? If there is nothing in the contract other than governing law clause and a seat, but without specifying anything in the arbitration agreement to say what the law is of the arbitration agreement, then the presumption is that the choice of the arbitration agreement, that the choice of law for the arbitration agreement is the same as the main contract. So that, I think, makes things a little bit well, whether you agree with that or not, that makes things a little bit simpler. There are sort of very extreme cases where sometimes the applicable law to the main contract would mean that if applied to the arbitration agreement is essentially ineffective. If that were the case, then that may rebut the presumption that the express or implied choice for the arbitration agreement was the same as the main contract, but those would be sort of pretty extreme circumstances. So that is the debate surrounding applicable law. For procedural law, it's common for the arbitration agreement to be silent also as to procedural law. And as I said earlier, this will usually be implied from the choice of the seat, although I think it's becoming less and less important actually, because if you have institutional rules, then they quite often govern the approach to the arbitration process. So I think it's becoming less and less important. I was going to move on to talk about interaction with the courts. Shall I just continue on to do that, or do we want to stop on applicable law given the interest in it?
I think we can take some questions here. We did get a question from an anonymous attendee with relation to devolved powers. That question is not very clear. So can I ask that person to send that question again, please? And in the meantime, I would like to ask a question, Angeline, because I think that it can get a bit confusing. If you have a situation whereby you do have a good arbitration agreement and you have specified the governing law for that arbitration agreement, and you have also specified the seat. Now, which issues do you take to either the governing law and which do you take to the seat? Because I note that in Enka v. Chubb, one of the questions there was the applicability of the arbitration agreement, and it also touched on scope of the arbitration. And I'm just wondering whether if you have a jurisdictional question, and let's say seat is London, but you have a contract under Kenyan laws. Yeah. And then you also say the arbitration is governed under Kenyan laws as well. So what do you do in which situation?
Well, in that particular circumstance, you have to be quite specific, because is the arbitration governed under Kenyan law, which would suggest adoption of Kenyan procedural laws for a London-seated arbitration, or is the arbitration agreement governed by Kenyan law? Because if in this one, the question being, what happens when the applicable law of the main contract is differed with that of the arbitration clause? If you have specifically set out in your arbitration agreement that the arbitration agreement itself is governed by a particular law, let's say it's expressly said it's governed by Kenyan law, even though the main contract itself is governed by English law, then Kenyan law would apply to the arbitration agreement as the applicable law of the arbitration agreement, and there's no difficulty with that. What is covered by that? Well, questions of, is the arbitration agreement valid? How should the arbitration agreement be construed? So what is the scope of disputes which have been referred to arbitration? And that is all really important, because it goes to the arbitrability, it goes to the jurisdiction of the tribunal. But what it doesn't cover is what is the procedural law of the arbitration. If in those circumstances you had arbitration agreement governed by Kenyan law, but London seat, then you could have, let's say the arbitral tribunal determined there was a dispute around the validity of the arbitration clause. The tribunal determined that properly as a matter of Kenyan law, but the seat was London, then any challenge to that award would need to be made in London. and the London courts would have to determine the question, the jurisdictional question related to the arbitration agreement as a matter of Kenyan law. So that's how it can get quite complicated, as you can see, but there is a method in the madness, as it were. Just on the, so yeah, this question about within a state to devolved powers apply, about whether, for example, London may have procedural substantive laws. Okay, so if the arbitration agreement said that the seat of the arbitration was Cardiff, then devolved powers are not relevant to this particular issue because it's the law of England and Wales. So the UK Arbitration Act applies in England and Wales. It doesn't apply in Scotland. So if you were to say that the seat is Edinburgh, then you would be looking to Scottish arbitration law rather than English arbitration law. So that's a sort of, I think, slightly niche point on the way in which, bizarre way in which our legal system operates in England. But for these purposes, Cardiff is part of England and Wales, and London, as is London. Now I'm just reading through the questions. Are you saying that the seat of arbitration doesn't determine the law to be applied? If yes, does it mean that the law governing the contract would govern the arbitration agreement? So it's a bit more, I mean, broadly speaking, the direction of travel is that if the arbitration agreement is silent about which law governs it, and it only includes a reference to a seat, but there is a law which is stipulated to govern the main contract, then the law of the main contract will govern the arbitration agreement. That's the direction of travel, but it's technically the analysis is a bit more detailed than that, because what the Supreme Court said in Enker is you first of all have to determine whether or not there's an implied or express choice of the parties for the law that governs the arbitration agreement, and where they've agreed that the law of the main contract is a particular law and the arbitration agreement is within that contract, they're presumed to have also agreed that the arbitration agreement is covered by that choice of governing law. But if there wasn't an expressed or implied choice, then you go to the conflict of choice, conflict of law rules, and there the seat may be potentially relevant in order to determine whether or not the parties had agreed to the law of the seat being the applicable law. But the reality is, I think, in light of Enker, that it's going to be very unusual circumstances in which the law of the seat determines the law applicable to the arbitration agreement. I'm not going to answer the question about USA state and federal law because I'm not US qualified. What exactly does the applicable law of the arbitration agreement govern? Is it the validity of the agreement? So it's the law of the arbitration agreement. If you think the arbitration agreement is just a contractual agreement, it's a clause. And so it governs the interpretation of that clause. It governs whether or not that clause is valid. In the same way as any other law would govern a contractual clause. That's what it covers. Right, someone at the bottom saying, I'm still regarding the applicable, is the law of the seat or the law of the main contract that governs the arbitration agreement? I hope I've answered that. So it is a bit confusing, but as I said, the direction of travel is, unless you've stipulated the law applicable to the arbitration agreement, it's likely that and you've stipulated the law of the main contract, it's likely the law of the main contract will apply to the law of the arbitration agreement, regardless of what the seat says. Christopher or Tabitha, is there anything else? Silence. Should I get on? Because I'm conscious that we've been going over and I've got a bit to rattle through on courts.
I think there are a couple of questions, but we could just proceed. I'll try to check and see which question is not answered, then we can rephrase them and refer them back to you at the end of the next part. Okay,
very good. So if we move on to 5, please, Angelica. And if you go on to the next slide, Thank you. So what I'm going to talk about now is the interaction with national courts. And this is the final section. What we're really looking at is the role of the national courts, because the support of the court for the arbitration process is critical to its success. As I've already mentioned, when a state has ratified the New York Convention, they're obliged to decline to hear matters which should be referred to arbitration proceedings, and they have to enforce arbitral awards. But there are quite a number of other ways in which national courts can be very important in terms of supporting the arbitration process. So over the next few slides, I've identified some of the key ones. The first moment of interaction with the court and arbitration process can be circumstances in which a party starts court proceedings in breach of an arbitration agreement. So they ignore the fact that they've agreed to go to arbitration, which is a binding contractual agreement, and they just start court proceedings. In those circumstances, under national arbitration law, a court is usually obliged to stay the court proceedings permanently, unless they find that the arbitration agreement is null and void, inoperative, or incapable of being performed. And it's the law of the arbitration agreement which would determine those issues. So the arbitration agreement is the equivalent of an exclusive jurisdiction clause, and it contains a negative obligation not to commence substantive proceedings. So, but where a party says, hang on a minute, there is no valid arbitration agreement here, then they are justified in refusing to go to arbitration proceedings. So in order to say, I can continue with these court proceedings, which I've started, you need to show the court that the arbitration agreement, the other side who is applied to stay the proceedings, is null and void, inoperative, or incapable of being performed. There is sometimes a bit of a tension here because there is a well-established arbitration principle of competence, which means, I think it's German, and what it means is that the tribunal should determine its own jurisdiction. So oftentimes the court proceedings, the courts will be very wary of getting involved in determining issues to do with the arbitration agreement, because that's primarily a question for the tribunal. Courts can look at it after the award has been made, but the idea is that you should refer it to the tribunal to determine it. But when you're looking at this question of whether or not there is a stay of court proceedings, this is one of the areas where the court might actually determine the issue finally between the parties. And the extent to which the court gets involved may depend on the nature of the issue being raised. So if, for example, the issue relates to the validity of the arbitration agreement, the court may go on and determine it, because there's only a yes or no answer to that. Either the agreement is valid or it's not valid. However, if the disputes relates to scope, whether it is inoperative, that may be a question which is more appropriately decided by the arbitral tribunal. And so it may be that the court looks at this and goes, look, I can see that there's plainly an arbitration agreement here. There's a question about whether it doesn't work or not, but that's not something that I feel, can be, that's something which can be properly determined or would be determined by the tribunal. If we can move to the next slide, please, Angelica. The next way in which the court supports the arbitration process is through interim measures. Now, what the model law provides, which is incorporated into many national laws, is that simply that it's not incompatible with an arbitration agreement for a party to request before or during arbitral tribunal proceedings an interim measure of protection from the court, and for the court to grant that measure. And also that the court has the same powers it has in relation to its own litigation proceedings for arbitration proceedings. So why would you need interim relief? Why would you go to a court rather than arbitral tribunal? Because oftentimes the tribunal would grant you interim measures. I mean, tribunals do have powers to grant interim measures. So a number of reasons why you would go to the court and not to the tribunal. One of them is that the tribunal doesn't have the same penal relief available to a national court. It cannot find parties to be in contempt of court, for example. And this can be particularly important when you have a recalcitrant party. Sometimes a tribunal may not be able to act quickly enough, and it's easier to go to the court. Sometimes you may need ex parte relief, for example, a freezing injunction, and you can't get that from a tribunal. Or sometimes you might need relief against a third party to an arbitration. And because the arbitration is established through party agreements, it's only the parties who are bound by the process, not a third party. So what are the types of interim orders which a court may be asked to grant? They could be asked to grant an anti-suit injunction, which basically stops a party from pursuing court proceedings elsewhere in favour of and requires them to pursue the arbitration. An order for preservation of evidence, orders for taking of evidence, freezing orders I've mentioned, appointment of an interim receiver, sale of goods subject to the proceedings, or orders relating to property subject to the proceedings. So there's quite limited on the safeguards and the court stepping in to act in the model law. There's quite a lot of additional provisions in the English Arbitration Act to regulate that process. So you can't go to the English court unless the tribunal cannot act ineffectively. You need to get tribunal permission to go unless the matter is urgent. And sometimes the English court will say, well, I've given you your order on an interim basis, but you need to go back to tribunal to get it done properly. So that's one way in which we differ from the international model law, but the principles are still the same, which is that, to the extent in which the court is being asked to exercise its discretion, it should be careful not to ride roughshod over the tribunal and only step in when effectively the tribunal can't do it. So if we can go to the next slide, please, Angelica. Challenge to arbitrator. You can apply to the national courts to remove your arbitrator. Now, oftentimes this is done on the basis of whether there are justifiable doubts to the impartiality or independence of the arbitrator, although there may be broader provisions in the national law. Actual bias is rarely used as a ground for removing an arbitrator. Apparent bias is much more common. The English common law test on this, which has been broadly adopted in other Commonwealth jurisdictions, is that an arbitrator may be removed where circumstances bearing on the allegation of partiality would lead a fair-minded and informed observer to conclude there was a real possibility the arbitrator was biased. And that's an independent test. The court puts itself in the position of a reasonable man or woman, and the fair-minded observer is imputed with knowledge of all relevant facts and takes account of professional standing of the impugned arbitrator. And that's something which has been the law for a long time, but it was recently reaffirmed by the Supreme Court in Halliburton. I should also say that where you have an arbitration under institutional rules and therefore administered by the arbitral institution, sometimes you have to go to the arbitration institution first, challenge the arbitrator before you can get to the court. If we can go on to the next slide, please, Angelica. Challenge the award. So the usual position is it's the court at the seat of the arbitration, which has exclusive jurisdiction to determine whether the award should be set aside. And the Untitled model law provides a very limited grounds on which an award will be set aside. And you need to bring that claim within 3 months of receipt of the award. The grounds are very limited, but as you can see from the slide, the first one effectively goes to whether or not the tribunal had jurisdiction. And even if the tribunal determines it has jurisdiction and it issues its award, the court can say, well, I disagree with the tribunal and set it aside. So that's a possibility on challenge to award. It's also there on enforcement. The next provisions really relate to the procedural fairness of the arbitration. So a party not given notice or able to present its case, disputed decisions which fall outside the scope of the submission. So when you refer your dispute to arbitration, you'll say what dispute is being referred. And if the tribunal determines another dispute, then that would fall outside the scope of the submission. The tribunal or procedure is not agreed. So if the tribunal was constituted using 4 members and the group arbitration agreement provided by 3, that wouldn't be following the parties' agreement. Or if the procedure for the arbitration, which the parties agreed, was not followed, that's also another ground. The final 2, subject matter not capable of settlement, is really the arbitrability objection, which I talked about earlier, and then contrary to public policy, which means that where the award on the face of it, to enforce it would be contrary to public policy in the court, under the national law of the court which is looking at this question, then they may set it aside. If it's a challenge or if it's resisting enforcement, they may refuse to enforce it. Public policy itself is very interesting because it really means public policy of the national law of the court which is looking at this question. But say, for example, there's been an allegation of bribery in the arbitration and the tribunals determined that there was no bribery, haven't looked at the facts. There's also a key principle of finality, which means that when the award is final, as you'll see from all of these grounds for challenged award, what we don't have in there is an appeal on the basis of law. It's to do with jurisdiction, procedural unfairness, or some sort of broader public policy argument. And so the way in which the English courts have grappled with that question is that they have said, well, we won't, if the tribunal has said it's lawful, we're not going to go behind that. That's the recent Privy Council case, Mauritian case of Betamax and State Trading Corporation. But if on the face of the award, it looks like it's unlawful, then we won't enforce it as a matter of public policy. And there's a famous case of Soleimani and Soleimani where it was a dispute governed by Jewish law. And even though the contract was in breach of all sorts of tax laws from procuring carpets, because it wasn't in breach of Jewish law, the arbitral tribunal still upheld the contract. But the English court said, well, we're not going to enforce that because on the face of it, we could see that this is essentially an unlawful contract and that would be contrary to our public policy. So it's the only way you can really get to the ground of public policy is if you can show on the face of the award that it'd be contrary to public policy. And if we can go to the final slide on this, Angelica, you'll see that the grounds for enforcement are the same as challenge. So that means the interesting thing about this is the courts that decide the challenge to the arbitral award are the courts at the seat. But you can, once you've got your award, you can take it to be enforced wherever in the world. Under the New York Convention, remember, there were 168 parties. So you can go into any of those national courts and seek to have the award enforced. But all of the same grounds will apply, save that it will be the courts which potentially you've not chosen. There's just where the assets are and you want to enforce the award, which just determine these issues. So I've come to the end of my basics of arbitration law. I think we might have time for a few questions. Tabitha and Christopher, do you want to take it away?
Okay, yes. So thank you very much, Angeline, for the lecture. Well, I understand that, especially the part of applicable laws, there are a lot of questions, so, and I still have to, take you back a little to that part. Now, if I just to sum up some questions, the way I understand the questions that were asked, there's some questions where they're talking about, instances where you have a party choosing a substantive law of a particular state in a country. For instance, I understand that in Nigeria here, you can have an instance where two parties are contracting and they say their contract will be bound by the laws of Abuja, which is the Federal Capital Territory. Or in, let's say it's in the UK, they might say London, or they might say London is the seat of arbitration. So in those instances, I think they might want to know if we'll have to, differentiate the applicabilities of the entire federal law from the specific law that was chosen by the parties. Like, for instance, will the Arbitration and Conciliation Act here in Nigeria, which has federal application, apply to an arbitration that parties have designated to be as designated Lagos, which is a state in Nigeria, and also has its own arbitration law? Would the ACA, that's the Arbitration and Conciliation Act, really apply to that kind of, a kind of arbitration like that? Then secondly, I think there are a lot of people are still a little confused as to the essence and the essence of these applicable laws. Like, in what situations do the law of the arbitration agreement come to play? In what situation do the substantive law come to play? And in what situation do the law of the seat of arbitration, which is also the procedural law, come to play. I think, do you deal with those questions, or I should also ask another question, because there's another question on procedure and arbitral institutional rules. Where where do those rules fall under? Is it under the procedural law? Do they go alongside with the law of the seat of arbitration or not? I think I should just take it slowly with you. Sorry, I've asked a lot of questions.
No, there's quite a lot in there. I mean, look, let me just try and give an example, because the applicable law issue is quite complicated.
Yes.
If we had let's say we had a consultancy contract, and that consultancy contract included an arbitration agreement in it. And the consultancy contract was governed by English law, and the arbitration agreement has the seat of Paris in there. Okay. Now let's say a dispute arises as to whether or not the consultant has been paid properly. That's the dispute. So the consultant basically brings a claim and says, I want to be paid for my consultancy services, and you haven't paid me anything. Then he's essentially got a breach of contract claim. What is the law which governs his breach of contract claim? It is English law, because the party stipulated that English law governs that contract. So that's a substantive dispute, and that's where English law comes into it. Now, let's say that the claim is brought by the consultant, but the company which he's contracted with says, hang on a minute, I didn't agree to arbitration. And he says, well, but there is an arbitration clause in there. He said, no, I didn't agree to the arbitration. I don't agree that the arbitration agreement is valid. And therefore, I'm not going to participate in the arbitration process. If the arbitration process has already been commenced, then it will be for the tribunal to determine whether or not there was a valid arbitration agreement. The law on which they will determine whether or not the arbitration agreement is valid and whether they have jurisdiction is the law applicable to the arbitration agreement. And in those circumstances where the arbitration agreement itself is silent about what law applies to it, then the tribunal has to decide what is the law that applies to it. If we follow Enker and Chubb, which is the recent English Supreme Court case, then they say, okay, you have to decide whether there's an express choice of law which governs that arbitration agreement. And the Supreme Court would say the parties did expressly agree what law governs the arbitration agreement, because they put a governing law clause in the contract for English law. And that contract includes a whole load of provisions, payment for consultant, the services the consultant would provide. It also includes arbitration agreement as one of the clauses of the contract. And therefore, by agreeing that English law would govern the entire contract, the parties have expressly agreed that English law applies to the arbitration agreement. So that's the perspective that the English court would take now. And so there would be probably very little dispute that the law which applies to the validity of the arbitration agreement would be English law. Now, let's say that arbitral tribunal, okay, so they say, right, I've got English law which applies to the arbitration agreement in that scenario. I've got English law which applies to the breach of contract claim. But I need to decide the procedure which governs my arbitration proceedings. And that procedure could be, do I need, as a matter of law, to have evidence on these issues, which are contractual construction issues? Do I need to have cross-examination on the evidence and so forth? All of those sorts of procedural issues. You might look to the institutional rules if they've any selected to decide that, but failing that, you would look to the law of the seat, which is, in my scenario, French law, because it's Paris seat, to fill in the gaps. So you may say, well, we're under a civil law jurisdiction, and therefore we'd be a bit more inquisitorial in our process rather than English common law, which is very adversarial. So in order to decide those questions as to validity of the arbitration agreement governed by English law, breach of contract claim governed by English law, the procedure which you apply to determine those issues is French law, because you're in a French law seat. Now let's take it a bit further forward. Okay, tribunal issues their award, and the party who the company who said there's no valid arbitration agreement still believes there's no valid arbitration agreement, even though the tribunal has decided against them. Because it's a para-seated arbitration, they will then have to go to the French courts to challenge that award to set it aside. And the French courts in those circumstances will look at the question of the jurisdiction of the tribunal by looking at, did the parties agree that the matter should go to arbitration, i.e. the arbitration agreement? And they will have to look at that, or they should look at that, according to the Supreme Court in Enker, as a matter of English law. Where this all falls down and gets complicated is sometimes the French courts may not follow that because they may have their own different views. But on our legal theory, they would have to look at that as a matter of English law, even though they're the French court. Now, let's say the French court agreed with the tribunal and they upheld the award. Let's say that the party go, okay, but I now need to enforce that award. So I'm going to take that award to Kenya, and I'm going to try and enforce it there, okay? So they bring it to the Nairobi courts and they try to enforce it in Kenya. But the company who maintains the arbitration agreement is not valid, he's still not giving up, right? He's still saying the arbitration agreement is not valid. At that point, in theory, he could raise a jurisdictional objection, but the enforcing court would still have to decide it as a matter of English law. But also, in addition, the Kenyan court at that point may say, look, you've already had this issue determined by the tribunal, by the courts at the seat, and it's possible that they would say that we don't need to look at that issue again or decide. I mean, it may be that you get re judicata issues, particularly if it's already decided as a matter of foreign law. But in theory, you can raise a jurisdictional objection, and in theory, it could be a de novo review. So that issue would come back, but the law which applies to it is unlikely to change. It would still, at that point, still be English law. Does that help explain the way in which it all fits together?
It does. Thank you very much, Angeline. So I'll hand over to Tabitha for further questions.
Thank you so much, Angelina. It's definitely helped to clarify it in my mind as well. And what's sticking in my mind is that issues of setting aside, you have to look at the procedural law rather than the applicability, or rather the law of the arbitration agreement. So we have a question here with respect to the section on the interaction between the tribunal and local court. And in this question, with respect to number 3 of interaction. So I don't know if maybe to answer that question, we can look at the slide. And then I can see that we're still getting some questions on the Enker v. Chubb test. But I think if we answer this question first, then we can come back.
Is this a question about the hierarchy of international law?
No, there's a question about this, about the number 3 of interaction between local courts is not clear. It's from Ukabam Adaora.
I'm not quite clear what the question is, I'm sorry.
Right, I think...
I mean, the slide 3 is talking about circumstances in which you can apply to the national court to remove your tribunal, if that helps. So you can apply to the court at the seat of the arbitration to remove an arbitrator. If you have institutional rules, you'll normally have to go use the institutional process to challenge an arbitrator first, but then you can go to the courts at the seat to remove the arbitrator. If you think that the arbitrator has been biased and perhaps you discover it after the award has been issued or so forth, you can then apply to set aside the award at the seat as well. So there are different routes to challenge what has happened if you believe that your arbitrator is biased. But this side is really dealing with circumstances where you want to challenge an arbitrator.
Okay, thank you. Thanks for that, Angeline. I think if Ukabam has any other clarifications required, you can just type them out. And then we do have that question about the hierarchy of international law. So they're asking, what role does hierarchy of international law play in respect to arbitral contractual relations?
Yeah.
In other words, where the arbitral contractual relations conflict with, say, the highest obligations under human rights or international law, where does the die fall?
I mean, it's an interesting question. It really, so I've given you the international framework for the state's obligations to basically implement national law to recognise arbitration agreements and awards. As you may know, many of you will know, for common law jurisdictions, quite often you have a dualist system, which is that the state has international law obligations, but they need to, just because they have an international law obligation doesn't mean that it's necessarily incorporated into national law. So when you're talking about human rights obligations, in order to really have an effect, I think, on the arbitration process practically, it needs to be incorporated into national law. So many of jurisdictions in Africa, or at least many jurisdictions have a written constitution, which is where you have your guarantees for human rights and so forth. In English law, we have the Human Rights Act, which incorporates the European Convention of Human Rights. So there are some times where human rights issues have come into consideration of arbitration procedure. And I'm trying to think off the top of my head what a good example of that would be, and I can't think of anything in particular, but it may be, that you have under Article 6 a right to access to the courts and so forth, and arbitration proceedings have certainly been determined to be compatible, I think, with that from memory. So in terms of determining the validity of the process, where there are human rights obligations as a matter of national law, then they may be relevant to determining the procedure, but it tends to come in particularly as a procedural issue, I think, rather than an issue of governing law and so forth. I hope that helps to answer that question.
Yes, I believe it does. I think that if I can just say that if any of the attendants have any other issue, then you can always reach out to us. I believe that was also stated by Angelica. So just to now close this particular discussion on the applicable law, there's a question here asking you, in your opinion, whether you would say that Enka v. Chubb test is the most preferred in international arbitration when it comes to choice of law applicable to arbitration agreements.
I hesitate to say it's the most preferred, because there have been, as I mentioned, there's been different approaches to this question. And I think, and I confess I haven't looked at it before I attended today, but I think my recollection is that French courts may have taken a different approach. I mean, I can see the sense of the Supreme Court's approach, which is that if you have a clause within a contract and you've decided what law will govern that contract, then there has been effectively an express choice of law for that arbitration agreement. But personally speaking, I have some sympathy with the view that the law should be more closely associated with the seat of the arbitration. And the reason why I've always thought that is because the courts at the seat of arbitration are quite often the courts that have to decide jurisdictional issues. So, but not exclusively. If you're applying to stay proceedings where the validity of the arbitration agreement is an issue, that may not be in the court of the seat. For enforcement, that may not be the court of the seat, as we've seen. But if you're going to challenge an award, it will be in the court of the seat. And jurisdiction is one of the main grounds of challenge. And many courts are very familiar with foreign law, but also foreign law tends to be dealt with as a matter of expert evidence in national courts rather than submission. So it always seemed to me a little bit odd that if you've got if the seat is Paris in my earlier example, but the law governing the validity of the arbitration agreement is English law, then the Paris courts are looking at the issue of jurisdiction. Just seemed to me that actually there's a very credible argument that the law of the arbitration agreement should follow the law of the seat, because it's the courts at the seat who will be determining, at least for certain, they will have some determination of that jurisdictional question. But the Supreme Court obviously took a different view, and I can understand why they did. So I think it's possibly one of those issues which will remain a bit controversial, but as a matter of English law, it is now settled for sure.
Thank you. Thank you for that. I think it's also worth just sort of watching the space, if anything comes out from this side on that particular point. It'd be quite interesting.
Yeah, I would be really interested to see that.
Yeah.
Okay, so Angeline, the last question, although I'm tempted to also comment on this, the last question that Tabitha just asked, and it's quite of a controversy. I know that in Nigeria here, the position is still more of tilting towards South America. And I think that's still what's still applicable in Singapore and some other countries. I mean, prior to the Supreme Court's judgment last year, the universal approach has always been towards South America's decision. So, but the last question we have is on the paucity of, ISD cases, as exceed, state investor disputes in, so the person is saying, what are your thoughts on there being very few disputes related to, investor state, exceed especially. So you see that there are cases where especially cases where states are complainants. So we see very few instances where states are complainants, or cases where state instigates at before exceed. So what's your comment on that? We have someone who asked that question.
So are there few
cases?
You might,
sorry to cut you short. You might also want to comment on the fact that, on the, the approach of most states. I know that some African states don't like investor, state disputes at all. So if you have any thoughts on that too, thank you.
Well, there are very few disputes registered with ICSID, especially cases where states are the complainants. Yes. So to be clear, normally investment treaty claims are started by an investor rather than the state, although there is debate about the extent to which states can bring counterclaims in investment treaty proceedings. I think that the topic of the way in which investment treaty proceedings are being handled and how comfortable states are with them is a really enormous topic. And I don't think that I could properly do it justice now, although perhaps we need to follow up with a session on that separately. But it's a really interesting topic, and I think we have to do it justice another time, because particularly in Europe, as you see, there's been, there's been quite a big backlash to investment treaty arbitration from the state side. I'm not sure I can really do much justice to that on this particular talk.
Sorry, I was just sorry for asking that question. I was just
no. It's a really interesting question, but one for another day, I think.
Yes, I know, but thank you very much, Angeline, for the lecture. I won't say that I've gained a lot, and I'm sure our audience too have done the same. Thank you for your time, and we look forward to having you next time. And also, I'm sure that if our participants also have questions, we'll reach out to you. So let me hand over to Tabitha now to give closing remarks.
Thank you, Christopher. So thank you all for joining us this evening. Please note that this session was being recorded, and so it's also available on the ALN Academy YouTube channel. So if you want to revisit any particular issue, you can very well do so, or you can share with your colleagues, friends, and fellow students that you feel would really value this masterclass introduction to arbitration. Final point, as we said, this is a collaborative training series between Africa in the Moot and the Lagos Court of Arbitration Young Arbitrators Networks. So please do look out on our social media for further trainings as we all prepare for all the different mooting competitions that are running right now. So thank you so much, everyone, and wishing you all a brilliant evening.
Thank you very much.
My apologies. I've just been asked from the YouTube channel to say from Victor Kihika that there couldn't be a better way of introducing international arbitration. Very resourceful, way too excellent. Thanks to all partners who made it possible and to Angeline in particular.